My name is Dina Blickstein, and I'm a partner at the law firm of Haynes and Boone. I specialize in artificial intelligence, technology transactions, and of course, post-grant proceedings. Joining me today are Jeremy Albright, David Tobin, and Roshan Mansingani. Jeremy, David, and Roshan, can you please introduce yourselves? Let's start with Jeremy.
Thanks, Dina. I'm Jeremy Albright. I'm a senior associate at Norton Rose Fulbright, and my practice is split probably 50-50 between PTAB trials and other post-issuance proceedings like reexaminations, with the other half of my practice being in patent prosecution.
And David?
Thanks, Dina. This is David Tobin. I'm a partner at the law firm of McDermott, Will, and Emery. My practice is focused on IP litigation. It's a mix between litigation at the patent office, the PTAB, and then litigation in district courts and some ITC as well. And happy to be here.
And passing over to Roshan.
Hello, everyone. My name is Roshan Mansinghani, and I am an in-house attorney, assistant general counsel at Unified Patents, which is a company that helps other companies, both small and large technology companies, deal with patent assertions.
And, thank you for joining me today, Jeremy, David, and Roshan. Now, we're about to get started, but first, let's thank our sponsors. So we have Mood, an online dispensary. We have Sunburst Digital, makers of the #1 typing application for education, grades kindergarten through 12. And Max Asset, restructuring and insolvency professionals. Finally, let's do a quick disclaimer. This material is for informational purposes only. It's not considered to be legal or attorney advice. If you needed attorney advice, please contact your legal counsel. And with that, let's get started. Now, Jeremy, let's start with you. Say I'm an AI startup and I'm considering to file a post-grant review. When should I do that? And should I really do that?
Sure. So one instance in which you should strongly consider filing a petition for a PTAB trial or post-grant review would be if you had been sued with a patent. I think that's the most common instance. PTAB trials usually come along with parallel district court litigation. And why you should consider a PTAB trial is, in my opinion, it's going to provide you the best shot at invalidating the patent that you've been sued with. This is for several reasons. I mean, the burden of proof in a PTAB trial is lower than in the district court, preponderance of the evidence versus clear and convincing evidence. And PTAB trials are also decided by patent-savvy ALJs rather than a jury. And so those ALJs are administrative law judges that can be more likely to get it right. Also, the chances of ultimate success are fairly high. Around 70%, I believe, of PTAB trials are instituted. And amongst those that are instituted, there's only around 5% that uphold all of the claims that are challenged. Of course, there is no requirement for litigation. There's no constitutional standing requirement. I think we'll get into that more later today to file a PTAB trial. So there's no need for a dispute. So you could choose to file a PTAB petition, maybe if you've discovered a patent doing some clearance or freedom to operate work that is problematic, and you can challenge that patent at the PTAB instead of obtaining clearance in another way, such as by redesigning the product or seeking to license a patent. You can challenge it at the PTAB instead.
So is it true that anyone can file in front of PTAB? Let's move this to Roshan.
So, as Jeremy mentioned, anyone can file a petition. However, there are some restrictions based on occurrences that would prevent you. We like to call them bars. So the first one is that if you choose to seek the invalidity of a patent in front of district court, through a proceeding called a declaratory judgment action. And in particular, that's an action in which instead of waiting to be sued by a patent, you affirmatively go to the district court and ask the district court to invalidate a patent, then you cannot file a PTAB proceeding. And the theory behind this, from a legal standpoint, is just that the PTAB was created to be a faster and more efficient alternative to district court litigation, but it wasn't created to give those who want to challenge patents multiple ways of doing things in parallel. So to help with judicial efficiency and the resources of both the court system and the patent office system, you can't file a petition to seek post-grant review trial at the patent office if you have already asked the district court to seek that it's invalid in a filing that you created. Second, if you have been sued on patent infringement and served with a complaint of that lawsuit, you then have 1 year to make your decision of whether or not you want to seek the patent office's assistance in canceling or invalidating the patent. So a clock is started essentially once you get sued. So that's another bar that we refer to as the time bar. And ultimately, if you have, for example, previously challenged the same patent and the same claims in front of the PTAB or the Patent Office, the Patent Trial and Appeal Board, that's what PTAB stands for, and you've received a final written decision, you can't go back and challenge it again, maybe with new research. That is referred to as estoppel. So while anyone can challenge a patent, depending on the circumstances, there are several bars that exist, mainly for the purpose of judicial efficiency.
There are a lot of traps to watch out for in PTAB proceedings, and one of them is actually with the service of a complaint, is if, say, a company is served with a complaint in district court, and then for some reason the case settles or the plaintiff voluntarily drops the complaint, that 1 year bar, the time clock keeps going. And so if the person decides to later challenge the patent, even though that complaint was dismissed, that 1 year time bar can still act.
And that's a great point, David, because once you serve, if you're being served with multiple complaints or you have a complaint dismissed, you're not really sure when the clock ticks. So it starts ticking from the earliest complaint.
Yes.
But what about the concept of standing? Does that come into play in PTAB trials?
So there's no standing needed to challenge, like in district court, Article 3, that's not really there for a PTAB proceeding because it is an administrative agency. But if you would want to appeal a decision, then you would need standing, similar to what Article 3 would be in district court.
Well, let's go back to pre-filing considerations. I guess timing does matter. There is a 1 year bar. Are there any other considerations that we need to think of?
One consideration I would recommend is that make sure the art you have is really strong. Unlike in district court, the parties serve invalidity contentions, which is more of a scattershot approach sometimes. Sometimes the art is good, sometimes the art is not good. At the patent office, you're dealing not only with experts in patents, but by statute, the judges at the patent office have scientific expertise. They're required to have, the statute says, competent scientific ability to serve as a PTAB judge. So you're really dealing with people who will get into the issues, really seek to understand them. And so if your art is not good, or your grounds are not good, they'll see it.
And to add to that, what this slide currently shows is also the specific procedure that you use, whether, and I'll give you what these acronyms mean as a reminder. PGR stands for post-grant review, and IPR stands for inter partes review. These two procedures are used, as the slide indicates, based on the timing of the patent that you're challenging and when it issued. There are some other considerations that flow from which particular procedure to use. And this can also impact, for example, whether you choose to file one or not. So specifically, IPR or inter partes review you can only challenge the patent based on whether it was novel and non-obvious in view of what had been previously known before, which in legal terminology we call prior art. PGR or post-grant review allows you to challenge on the same bases as IPR, that is, in view of the prior art, but also in view of other challenges. For example, if the patent claims something that it actually didn't describe or describe well enough in its description, you can challenge on that basis as well. And that is sometimes a stronger basis of invalidating a patent than the prior art basis. And so if you had a patent that was eligible for PGR, and as the slide indicates, that's typically challenging it within 9 months of when it issued, you may want to consider this type of challenge in front of the patent office because, as David mentioned, you have expert attorneys working within the patent office to really get into the details of these things, as opposed to having, and that have to issue a written opinion that you can then appeal before the federal circuit, a circuit court. As opposed to trying to bring these same claims in front of a non-technical jury or judge who may not understand the issues as well from a technical standpoint.
Jeremy, do you have anything to add?
I think that covers the additional timing requirements beyond the 1-year bar pretty well, and they're on the slide. I mean, again, PGR, you got to act quick after it issues, and so likely you're going to be aware of that of that patent, right? To act within that 9-month window after it issues. I guess one thing I will add, we talked about the 1-year bar. I think it's important to note that even though the statute gives you 12 months from when you're served with the complaint, it's likely going to behoove you to file your petition for a PTAB trial earlier in that window rather than later. Because if you file too late in the window and you're sued in a district court that moves quickly, you may end up in a situation where the PTAB's not going to decide on your petition, which takes around 18 months from when the petition is filed. Usually just a little bit longer than that. It may be that the district court will already have gone to trial by that date, and that's a reason why the PTAB can discretionarily deny an otherwise timely petition, because one of the aims of the PTAB is to be an efficient alternative to litigation. And in that instance, it wouldn't really be an alternative because it's going to be in parallel, and actually the litigation is going to reach trial before the PTAB issues its final written decision. So again, better to file earlier in that 1-year bar window, that 12 months from service of the complaint, than later.
Now, to put it in a frame of reference, how long does it take to prepare one of those petitions? And I'll open it up to anyone.
So this is it. So you first have to find the prior art, which can take time. But assuming you have the prior art in hand, but the reasonable time period could be a month or so. I mean, a lot needs to go into a petition. In fact, your whole invalidity case goes in the petition, and it's not, well, let me write something now, see what they're going to say, then adjust or pivot, but you're expected to put your whole case in the petition. So it needs to be good, it needs to be understandable and persuasive. So once you have the prior art in hand, say about a month or so.
What is your experience, Jeremy and Roshan?
Yeah, I think IPR petition or a PGR petition, it's like a motion for summary judgment. And echoing David, you have to have your whole case in chief and all of your evidence together when you file the petition. You're not going to be able to really add anything to it later. You may be able to respond to arguments that the other side makes, but there's not going to be any bolstering. You can't change your position. And so I've worked on cases where even when we have the prior art, it can take 2 to 3 months to get the petition together. And I mean, it's important that it be as good as it can be, because I view it as it's really your shot at invalidity, and you're not likely going to get another one.
And that's particularly true, exactly what Jeremy said, because you're not going to get, you may not get another one, because once you file your petition, and if the board institutes, they decide to go forward with your petition, once you get a final written decision, estoppel will start applying. So for an IPR, you may not get to raise patents or printed publications again. And for PGR, if there's a district court case, it very likely means you don't have an invalidity defense at trial.
Now, what
Yeah,
is?
I'm
Oh,
sorry.
Go ahead, Roshan.
Yeah, so if we were to synthesize what Jeremy and David brought together, and if we were to try to take a step back and look at this from the perspective, if you're just a CEO of a company that got sued on a patent, what that timeline looks like, you first have to contact your attorney that you want to represent you in the litigation. They then have to kind of review the patent. The searching for the prior art, as David mentioned, can take 1 to 2 months alone just to try to find the good research, depending on the case. And then at the same time, most attorneys who counsel clients in patent litigation also want to understand the other issues of a patent, namely, do we do what the patent says? And so there's an initial sort of understanding of that. And so the sort of a realistic time frame from start to finish in terms of you're deciding to even research the prior art to actually getting the petition on file is 3 to 6 months and sometimes up to 9 months. So the point is, if you are just listening to this and wondering and you're not in the weeds of it, is it's a decision that you're going to have to come to fairly early, like within the first couple of months. You're going to want to talk to your counsel about whether this type of challenge makes sense, because the entire process, while the writing part might only take a month after you've done all the research and found your prior art, there's a lot that goes up to the strategies as well as the research before you get to the point that you can put pen to paper on the actual petition itself. That also includes finding a technical expert who's going to write a declaration that's going to support your petition. So as Jeremy mentioned, this is really like putting your case in chief, even though it's a portion of it, in front of the patent office. And so most of the time from the date you're sued to the time most petitions get on file, between 6 to 9 months, because you're taking all these things into account.
Let's talk about standard of review. What is the standard for IPR and the PGR? And let's also compare that to district court litigation standard. All right, David, Roshan.
Yeah, I was gonna jump in on that one. So at district court, many people understand that some of the standards of evidence, but as this slide shows, it's probably helpful for us to remind ourselves of what it is. So for the patent owner to prove that you infringe the patent at trial, we use the preponderance of the evidence standard. But what's not intuitive for most people is that to prove that the patent is invalid in district court, there's a higher standard. So the tables are not even. The playing field is not even in the context of a district court litigation. The patent owner actually has a lower burden at trial. All they have to show is a preponderance of the evidence, over 50%, 50.1%, as most people think of it, to show that you infringe. But to show that the patent is invalid, you need to have clear and convincing evidence. So another standard people are familiar with is beyond a reasonable doubt, which is what's used for criminal trials. It's not that high. That's not on the slide. So clear and convincing evidence, though, is sort of one step below beyond a reasonable doubt. And what it basically means, right, is that you have to basically answer most questions as a resounding yes, as opposed to more likely than not. At the patent office, though, when you are challenging the patent, there's two steps. So the first step is the case good enough to move forward, what we call the institution phase? And that's what this slide is showing. And then there's the final decision that the patent office will take. At the institution phase, it's simply a reasonable likelihood of success. So in other words, if we take all the facts and anything that's in dispute, we somewhat resolve them in view of the petitioner. Have they made a logical case? Does the case make sense if we believe the petitioner? And that's effectively what the patent office does with the reasonable likelihood of success. However, to actually win the case and to show that the patent is invalid, all you need in the patent office is the preponderance standard. So again, that's that 50.1% rule of thumb type of analysis where the patent office is looking at the evidence to decide whether the patent is actually invalid or not.
Okay, now let's go back and talk about the petition. What does a petition for an IPR or PGR include?
So there's something called the Trial Practice Guide, which is a publication by the United States Patent and Trademark Office. It's kind of a guide towards practitioners of all that you need to do that summarizes all the statutes and regulations, and they tell you all the things you need to include. So one of them is you need to identify the real party in interest that besides the person whose name actually or person or party whose name appears on the petition, who else has a stake in this matter? Who else is funding it, for example? What other relationships are there? So you need to identify that. You need to identify the challenge claim and the grounds for challenge. Here, it's very important to actually be clear on why you are saying the patent is invalid. So, for example, the patent office does not like saying the and/or other hedge language. They want you to be able to clearly state this claim is invalid as anticipated by this reference, or this claim is invalid as obvious by this combination of reference. So be clear in what you're saying the basis for invalidity is. Oftentimes there is no special claim construction, but if there's any kind of disclaimer during prosecution or special meaning given to the terms, you should identify that in the petition itself, and then show how the prior art matches the claims under that construction. Typically, petitions are filed with a number of exhibits that includes the patent that's being challenged, pieces of the prosecution history, an expert declaration, the prior art itself, maybe some background references, educating the judges about this specific technology. All of that should be included in the petition itself. And that's part of the copies of the supporting evidence. They all get filed together. There's other things like the power of attorney and other such forms, but those are the main ones. And again, any evidence that you know of that you are relying on or that you think you may want to rely on, you should be filing with the petition because it gets harder to introduce new evidence as the case proceeds. And like Jeremy mentioned, this petition is your case in chief. So anything you are relying on or think you might want to rely on, you want to make sure that it's in the record so that you can cite to it as needed.
Now, those petitions have page limit, right? So can you really include all the evidence or do you need to be selective?
So the petition now, they've changed it more towards word limits where you have about 14,000 words for and it's crazy, but we're actually counting words and that's done in, the trick is always getting it within the word limit. So it's always a matter of shortening, but if IPR is 14,000 words and post-grant review is 18,700 words. So yeah, I mean, if it's a piece of evidence yeah, that you think you'll rely on, yes, you should include in the petition. Now, this is not a goal of identifying hundreds of exhibits and anything and boiling the ocean and putting that all in the exhibits. It's really the relevant pieces of evidence that you think you will use or may want to use. And if there is a piece of evidence you'll want to use, you at least want to cite it in the petition or say something about it.
And that's right. And I'll add to that. Just for clarity's sake, the petition is where you write your arguments and you cite to evidence and you sometimes quote it, but it's not the evidence itself. So the number of words that you're limited to, that 14,000 number that David mentioned, is only in the petition. So it's like your main set of arguments. The actual evidence, for example, the pieces of prior art, your expert declaration, and then corroborating references for your expert declaration does not count towards the word limit. However, as David mentioned, what you can't do, and the board will exclude pieces of evidence or not give them weight, is if you just try to fill the record with, let's say, 100 pieces of evidence, you only actually rely on 10, but you have them in there just in case to be able to rely on them later. That's a strategy that many people are used to in district court. It's not allowed in the patent office.
Right.
So any piece of evidence that you include with your petition, like even though it's not subject to the word limit, at some point should either be referenced by your petition or by your expert declaration that supports your petition, and in the best practice, both. So there are some practical limits given the word count there. But it is important, as Jeremy highlighted at the beginning, that you have to put all of your evidence that you're aware of in this petition. And that's actually why, as most attorneys will tell you, word limits, even though they should make documents shorter, they actually extend the amount of time it takes to draft the documents, because you have to make very difficult decisions sometimes as to what evidence to keep in versus keep out due to the practical limits of the practical limitations of what you can cite.
And Roshan has a great point on that to follow up. That also means that you can't assert 20 grounds of invalidity in your petition from a practical matter because you're not going to have the space to go ahead and explain them. So that's why it's important to really have rifle shot, get the really strong grounds and fully develop them, fully explain them. And on the exhibits point, people in the past have gotten in trouble where what they'll do is they'll do an expert declaration in a lot of detail. And instead of actually putting the arguments in the petition, they'll say, go see paragraphs 27 to 54 of the expert declaration. And the PTAB says, no, that's an end run around the word limits. They don't like that. On the other hand, they also, if all an expert declaration does is verbatim copy the petition, the PTAB won't give the expert declaration any weight. So again, all of this is a balancing effort, the Goldilocks approach, to make sure you have the right amount of argument in the petition itself and you fully explain your grounds. But then also you have the right grounds, not too many grounds, not too little grounds, but the right amount of grounds to cover all the claims and bases of invalidity that you're asserting, while also making sure that the arguments are very strong.
Now, let's talk about the fees. How expensive are these petitions? Jeremy?
Yeah, so in governmental fees, just to get them on file, PTAB petitions are they're expensive. For an IPR, the current fee, governmental fee, just for filing the IPR petition is $41,500 for up to 20 claims. If there are more claims, there's a per claim upcharge on that. And for a PGR, which is it's a more involved proceeding with more challenges that can be raised, as mentioned earlier, it has a higher word limit. That's $47,500 for up to 20 claims. And again, it goes up if you need to challenge more than 20 claims.
Now, though, I heard those fees are about to change next year. Is that right? Hopefully they'll go down.
Right. So I actually looked into this preparing for our discussion today and was surprised. They're going up in 2025, and they're going up substantially, about 25% for a PTAB, for filing a PTAB petition. So an IPR is now going to be in 2025, $51,875, just governmental fee to get it on file. And a post-grant review petition is going to be $59,375, so almost $60,000. And again, each of those figures is just for 20 claims. If you have to challenge more, there's going to be an increased cost associated with that.
These things never get cheaper.
Now, David, for comparison, how much is it to file a complaint in a district court?
Again, depending on the level of detail and technology, but the level of complaint is, for just the filing fees is a few
Just
$100.
the filing fees.
That's like $400 or $500.
Right, so as you can tell, the difference is quite significant.
Yeah.
Okay, so let's move on and talk about what kind of grounds can be raised. And let's again reiterate the difference in the grounds between an IPR and a PGR. Roshan?
So the process, as envisioned by Congress, was to invalidate patents or to challenge the validity of patents based on things that were fairly objective, where you didn't need a jury to try to believe a witness or not a witness, just kind of what was written down in paper. So the more simple proceeding to understand is IPRs, where the only basis of challenge is really, from a layman's perspective, whether the patent was really new or inventive. To use some precise legal terminology for those that are in the know, that would be whether the patent was novel or non-obvious, and that handles sections 102 and 103 that you see on the slide. Now, the grounds that you can use are only based on patents and printed publications, so written documents, essentially. For PGRs, because these are at the very beginning of the life of those patents in terms of when they issued, you can also challenge on several grounds that are listed here. This won't be exhaustive, but the point is you can still use the whether it's truly new or inventive, which are the novel and obviousness issues I addressed earlier, but also importantly and most specifically, whether the patent actually claimed what we call eligible subject matter. So to make this simple, patents, you can only get patents on certain types of ideas. For example, you cannot patent a mathematical formula or a law of nature like gravity. So there's been a whole complex set of rules that are around whether certain patents actually claim eligible subject matter or not. And there's a whole framework for analyzing that. And so you can't challenge that in IPR, but you can challenge it in a PGR. And then finally, I mentioned it earlier, there are requirements in a patent. For example, you can't claim something you didn't describe in your patent application. Or in the printed patent itself. So if you did claim something you didn't quite describe accurately, and it somehow got through the examiners in the first instance, that is where you can make what we call a written description challenge. And that's under section 112, which is listed there on the slide. So those are the basics of what you can cover and the basic nuances between them.
Yes, I like how you refer to patent eligibility as simple, Roshan. I think for anyone practicing in that space, it's anything but simple. But you can also envision a scenario where there was a 101 rejection in front of the patent office, the patent issues then, and then you have a PGR with another 101 challenge. All right, so let's talk about the level of scrutiny. What is the level of scrutiny that PTAB apply to request for trial? David?
So again, the judges will read the petition. They will read what the patent owner files as well. They will get into detail of the arguments, really try to understand it. So again, as we said a few times, it's very important that you view this whole PTAB proceedings as a rifle approach, not a scattershot. You want to get strong grounds in there that are well supported with evidence. You need to be clear as to what you're saying. So for example, the example I've seen is in an obviousness combination where petitioner is asserting that a patent claim is obvious over a combination of reference A and reference B. You should be clear, are you seeking to modify reference A with reference B, or are you teaching to substitute pieces of reference A with reference B? And the PTAB looks for these kind of things. And for example, when you eventually have the hearing, you will get pointed questions. Again, some judges are more active than others on the bench, but you will get pointed questions as to what this reference says or this reference teaches. And they will, I've seen judges actually read the reference and will ask, well, if this page of the reference, it says this, how does this relate to your arguments? So the short answer to your question, Dina, is that they give it a high level of scrutiny and that they really get into the issues and seek to understand them.
Let's go back to timing. How long is the PTAB proceeding once it's instituted? Maybe Roshan can take that one.
Sure. So let's talk again about the timeline of what happens in these PTAB proceedings. So a petition is filed, and then the patent owner can choose to file a preliminary response if they want, and then the patent office decides whether the case is meritorious enough to go to trial, is what that's called. So that first half, pre-institution, lasts a bit over 6 months in the typical scenario. If the patent office chooses to institute trial, and as Jeremy indicated, it's in the high 60 percentiles, low 70 percentiles, depending on the year you're looking at, then the Congress and the statutes that created this proceeding require, in most instances, for the final written decision to issue 12 months from institution. So that's basically a hard and fast rule. The judges or the parties can seek a variance on that and extend it another 6 months, but that rarely happens. I think it happens in, I would even say, less than 1% of cases, certainly in the cases I've been involved in. I've been involved in probably over 100, between 100 and 200 cases, and it's only happened once, and it was a very rare case that in which it happened in the cases I've been involved in. So effectively, once you get instituted, you can bet that your, with a high degree of certainty, that your final written decision is going to come out within 12 months, usually in the 10th or 11th month from when you file. So you put all that together from the filing of the petition to the final written decision, plus or minus is in the 18-month timeframe.
And something that's been happening lately, I think, due to the backlog, is the file date is not necessarily when you go ahead and click submit on the website, but there's our paralegals at the patent office that review everything, make sure all the pieces are there. And sometimes they take their time doing that, I think, to give the judges a little more time. And so that may be 3 weeks after you click the submit button from petition filed starts, but 18 months plus a few weeks is a pretty good approximation.
Now, what about claim amendments? Can claims be amended as part of these proceedings?
They can, shown on the slide, the deadline to do that is 3 months after institution. It's the patent owner's choice. Oftentimes, the patent owner will not amend the claims because that can create intervening rights where and cut off past damages. But where a patent owner does choose to amend the claims, they can do it in 2 ways. They can file a motion for a contingent amendment or what's called a non-contingent amendment. If they do a contingent amendment, what that means is that the patent office will consider the patentability of the original claims. And if the board, the Patent Trial and Appeal Board, decides that the original claims are not patentable, then they will look at the contingent claims and see if those are patentable or not. If the board decides that the original claims are patentable, then they don't address the contingent claims. There's also non-contingent, and I've seen this done For example, if certain claims have indefiniteness issues or other issues that the patentee wants to fix, then they can file what's called a non-contingent motion to amend. And what that means is they tell the board, you don't need to concern yourself with the original claims. These are my new proposed substitute claims, and are essentially giving up on the original claims. At that point, after a motion to amend is filed, the patentee can seek guidance from the board. It's in the form of an advisory opinion from the attorneys, where the board will say, we think your new claims are patentable for these reasons, or not patentable for those reasons. And then what the patent owner can do is decide to file a revised motion to amend, where they try again and propose another set of claims. And of course, there's briefing throughout each of these processes, but with the new amended claims, there are a few additional requirements that come into play. First, you can only propose a reasonable number of new claims. You can't go ahead and start with 20 claims and now say, well, my patent's now going to have 100 claims. Typically, a 1-to-1 ratio is considered reasonable. The amendments you propose have to respond to something that the petitioner raised. They have to respond to the grounds of unpatentability. A patentee cannot what's called enlarge or broaden their claims. The claims have to only narrow from how they were, and they can't add new matter, something that's not supported in their patent. This is a little bit of a hot button issue, the motion to amend, because we've been operating under the last 5 or so years under what's called a pilot program. It was temporary. The patent office proposed new rules just a few months ago in March to take this pilot program and make it permanent. So that hasn't been enacted yet, but it's on the way towards becoming permanent.
Now, are people actually using motions to amend claims, or do they go to different venues? Jeremy?
Yeah, so I've been involved with a few motions to amend, and I've also tried different venues, as you mentioned. I mean, at the end of the day, in my experience, I'd love to hear what the other panelists think, is that amending claims at the PTAB is quite an uphill battle. Once you propose your substitute claims, they're going to be subject to all of the patentability requirements. And so the other side's going to be able to raise subject matter eligibility concerns or issues that we talked about earlier. Also 112 issues, that would be written description, like whether the substitute claim is adequately described and fleshed out in the specification. Indefiniteness issues, so the substitute claim is unclear, and so you have all these additional challenges now. It's not just 102 and 103 novelty and obviousness over printed publications, and you're not in a traditional prosecution setting where you're working with a patent examiner. At the PTAB, you have a seasoned opponent with resources and an expert who's going to be attacking the validity of your substitute claims. We've had success instead filing a request for ex parte reexamination. That can actually be done even after an unfavorable, if you're the patent owner, final written decision is issued. You can file an ex parte reexamination and get your claim amendments that way. And that's going to be a setting where you're working with an examiner. Now it's not just a normal examiner. Those are handled by the central reexamination unit. So typically it's going to be a very experienced examiner, and actually it's a panel of examiners that work together. But being ex parte in nature, it's you in the patent office working through the issues rather than you and a very savvy opponent with resources. I think your chances in the ex parte reexamination of successfully getting amendments through is just much better. I would say if you are going to amend at the PTAB, the program that David mentioned, I would definitely take advantage of that. Get the preliminary guidance, and if the preliminary guidance raises issues with your substitute claim, to file a revised motion to amend. And they actually implemented that because the success rates on motions to amend were just abysmal. And then I'm not sure what they are now. I'm sure they've improved somewhat through the pilot program, but I got to believe the success rate is relatively low.
Now,
Yeah,
can
to speak to
we
that.
do both?
Oh, I'm sorry.
No, Roshan, go ahead, sorry.
No. So Dina asked a question that I think Jeremy should answer. Can you do both? And then I'll jump in on the data.
Yeah, you could absolutely do both. So you file your motion to amend in the IPR. Let's say it's a contingent one. The original claims are found to be unpatentable, and then they would consider your contingent claims. And if they were found to be unpatentable, I don't see why you would be precluded from filing a request for ex parte reexamination, although whatever you put in the motion to amend, those substitute claims are going to be subject to patent owner estoppel. And so whatever your amendments were in the substitute claims is probably going to be taken off the table for the subsequent work in the ex parte reexamination.
That's right. So to Jeremy's point, theoretically, to Dina's question, you can do both, right? The statutes don't prevent you from doing both, but the practical reality is that it's very difficult to do both. One reason is that if you think about what's actually happening here, you have an IPR filed against you. If you at the very beginning of that try to file a reexamination initiated by the patent owner, because you're sort of looking at what the IPR says, and you're like, yeah, you know what, I think I need to amend my claims, and you try to get a reexamination in. One of the things that the patent office can do, because they're trying to conserve resources, is stay the reexamination pending the outcome of the IPR. If they do that, then your claim can get invalidated while the reexam is stayed, at which point they would dismiss the reexam as moot. I've actually seen this happen before, where there's co-pending reexaminations and IPRs. Now, in the context I've seen it, it was actually another person trying to challenge the patent, not the patent owner trying to amend their claims effectively. And so it was initiated by another opponent, if you will. So that's one issue. But to get to Jeremy's other point about success rates of amendments by the patent owner, they are much higher in reexamination. Exactly. So there's actually data that's come out on both sides of this. The Patent Office publishes data on motions to amend, specifically in PTAB trials. And they recently published in the past couple of months, I believe, their most updated study. And it still shows that rates are low. They're not in the single percentiles, but they're like barely above 10%, somewhere between 10 and 20%. Then if you look at the parallel statistics for the reexamination side, they're above 20%. So then the 20 and 30%. So it's almost double the rate of amendments that are filed in and successfully obtained in reexamination than in IPRs. So you trying to do both at the same time, though, is very delicate. And it's actually quite a bit of a challenge, which is why most people, if they're going to try to amend, try to do so in the context of an IPR. What you can do, though, is let's say the IPR completes and you've got some claims that survived and some that didn't. You can then file an ex parte reexamination as a patent owner to then sort of craft claims that you think are still that you would desire. So there's no bar or estoppel for a patent owner to try to amend their claims, other than if they try to amend their claims to basically the same form that had already been invalidated by the IPR or the PGR, right? That's the estoppel Jeremy was referring to. That if the patent office has already decided in one context that claim is invalid, you can't get another bite at the apple by filing a separate proceeding and coming up with clever amendments to try to reclaim that same subject matter. But you can go after more, for example. So maybe your motion to amend fails, but there was something you left on the table, another amendment that you could have added that you didn't do it in the IPR. You can certainly file a reexam after the fact to try to amend those claims further.
Right. And of course, there's the intervening rights issue. So your damages may be reduced quite a bit if you're trying to amend claims.
So yeah, David, maybe you could explain that because I'm not sure how much our audience would be familiar with that because that's another downside to amending that we should talk about, and it's a big reason why there's not a lot of amendments in the first place.
Sure. So the statute was originally created for something called reissue, but it also applies to reexaminations and IPRs as well. And what intervening rights does is if the claims get amended, then if the claims are substantively amended, that is, fixing a little typo here doesn't count, but if they're substantively amended, then all prior damages before the issuance of that patent get cut off. But another consequence of intervening rights is that if, let's say, a competitor, not the patentee, made substantial investments in products or actually had products in existence, the competitor can argue that they're entitled to something called absolute intervening rights. So any products that are already in existence, they can argue they get to keep selling and using free of the patent which was amended. And they can also argue that if they made substantive preparation towards developing a product or continuing the product, they can continue using that product. And there's some other factors that come into play as well, but it could severely hamper the value of the patent through intervening rights. So it's something that should be considered before amending, and it's also something that should be considered by a person filing an IPR. If they want to try to provoke an amendment, that this is another benefit that they could get.
All right, so let's move to the fun topic of multiple petitions, right, on the same patent, right? Suppose there's multiple petitions on the same patent. Is this something, as the petitioner, I should be worried about? Roshan?
So the answer is yes. Over the past few years, the Patent Office has created basically a set of factors that they'll look at and decide whether a second or a third or a fourth petition by the same petitioner or another petitioner will be what's called discretionarily denied. So if we think again about our timeline of when of how a PTAB proceeding occurs, there's that initial step where the Patent Office will take will make a decision on the petition, right? And so far we've been talking about today about the substantive factors, how strong is the evidence, how strong is the case. But there are a set of what's called discretionary factors where the Patent Office can exercise discretion to not institute, even if it's a meritorious case, even if you got a slam dunk case of invalidity, they can still choose not to institute if they want, based on discretion, on various factors. And one of them is, have there been multiple petitions that have been filed? Now, the reasoning behind this is that they don't want the patent owner subject to effectively what I like to say, death by 1,000 paper cuts, right? There is a way to economically, if you're someone accused of patent infringement and you got a lot more dollars than the patent owner, then you can just file 100 petitions and basically bankrupt the other side on having to defend those because you have enough money to leverage it on that. So to prevent those types of gains, the Patent Office has said, hey, if you're going to file a petition, you better just file one, right? That really covers what you want. You can try to file two in certain circumstances. We may allow both, but we really don't want you staging your attacks. We really want the best case forward at the very beginning. So yes, if you are going to file multiple petitions, you have to really think about how to do so. One sort of insider tip of doing it well is if, for example, you don't have enough words to try to get at all the evidence you want, what you can do is break up your case into two petitions based on which claims you challenge. So for example, patents typically have 20 claims. You might challenge claims 1 through 10 in one petition on, let's say, 3 or 4 grounds, and claims 11 through 20 in another petition. And in that instance, the Patent Office won't really consider the discretionary factor since it's technically two different sets of claims you're going after. So what the Patent Office has been doing through their practices over the past few years has been trying to curtail perceived abuses of the system by petitioners in filing multiple petitions.
And one current events update is that everything Roshan said has been in the PTAB cases that they've issued over the last few years. And as of April, they announced proposed rules to take these, they're called the general plastics factors, and actually put them in the federal regulations to make them formal rules. So far, they've just been case law that all the patent judges follow. And there's also an issue, not just of one petitioner filing multiple petitions, but you see it where there's, let's say, patent owner sues two different defendants in district court, they're co-defendants with each other. And then those two co-defendants trying to ping pong off each other with multiple petitions. And so this discretionary denial Roshan was talking about has been extended to if co-defendants, for example, go ahead and try to file separate petitions.
Okay, so thing to remember, essentially PTAB frowns upon multiple petitions, whether it's by the same party or by different parties.
Right, and there's exceptions to everything, but it's all definitely something you need to consider and think twice about.
That's right. Yeah, and I would just add, the multiple party situation is problematic for the PTAB if, as David mentioned, it's basically two parties sued, maybe not in the same lawsuit, but at the same time, and they've sort of ganged together. But if you have a scenario where a patent owner asserts a patent against one petitioner and they file, and then 7 months later, the patent owner files against a second completely unrelated company, and that company is trying to decide whether to file or not, typically, if that company then files later, the patent office is not going to use its discretion to deny because someone else already took a shot, because the patent office is trying to balance everyone's right to challenge this patent, especially when they've been sued on it, with the gamesmanship we've been talking about. So your kind of rule of thumb is, does the patent office see some sort of collaboration or gamesmanship between the two parties that filed that separate petitions? That's what their factors are really trying to get at. And if they're not, and it's really just a product of the fact that the patent owner has chosen to assert its patent against several companies, then typically each one will get its shot and they won't be frowned upon for taking a shot.
Right. So Roshan, going towards your scenario where you have two unrelated parties,
Yeah.
can the second party essentially use the petition by the first party as a roadmap?
That's a great question. So the patent office has frowned upon sort of what we would call the road mapping issue. So let's say you're completely unrelated parties, you're not collaborating, but the second petitioner strategically decides to wait to file because they want to see what happens to the first petitioner's case. And they see that there was some chink in the armor, so then they try to use that as a roadmap for creating their own petition. Again, the patent office is going to generally frown upon that from a gamesmanship perspective. Now, sometimes that just happens naturally based on the timing of when you were sued. So, for example, there's no problem with learning about sort of what happened in a first petition if you weren't even sued till after that first petition had reached a decision point, right? So the patent office is really going to look at the timing of when you were sued, when you chose to file, and whether you were waiting on seeing what the patent office did with the first case. My personal opinion is I don't like this rule. I mean, I don't see the problem with, a litigant or someone trying to learn from the patent office and understanding what they find to be important. But again, what they're trying to do is avoid abuses of the system to put the patent owner in a difficult position, and they're trying to balance that consideration out. Which is why they have instituted these soft rules, but as David mentioned, are sort of in a proposal right now to become more hard and fast rules.
And again, there are other ways to join the fray if you're late to the game, such as there's joiners. You can file something and say "me too" and use if you file your own petition, you say if you institute their petition, I'll join them. Don't consider mine. But if you are going to deny theirs, then take a look at mine. So again, there's exceptions to every rules and ways to do things. But the overarching theme is they are trying to avoid gamesmanship and unfair collaboration against the patent owner.
Okay. So let's touch on this very briefly since we're almost out of time. I mean, there's a district court litigation, there's litigations, but there is PTAB proceedings. There's also an ITC litigation. Can one of you comment on what ITC litigation is and how does it affect the PTAB proceedings?
Very briefly, so the ITC is International Trade Commission. It's an administrative body that is trying to prevent unfair importation into the United States of infringing goods. They can block entry of those goods into the United States. And they will also look at validity of the patent, but their validity finding just means that they won't impose a remedy. It does not cancel a patent or render a patent invalid. So what the ITC says will not act as an estoppel or have some kind of deleterious effect at the PTAB, just because they don't have the statutory power to render a patent invalid.
Okay. And how does it affect the PTAB proceedings when you're thinking if you should file?
Well, normally the ITC will finish before the PTAB. So again, I think the PTAB has a much bigger impact in district court and how the two relate to each other. Some people will still file a PTAB petition at the PTAB if they're sued at the ITC, just in case, for example, they have a bad outcome at the ITC and the goods get blocked from entering the United States. Then there's sort of a second effort to go ahead and if the patent can be rendered invalid later as a to basically save the good.
All right, so we're out of time. I'd like to give a big thank you to our panel, to David, Jeremy, and Roshan, and also a big thank you to our listeners. We had a fantastic panel with the district court, patent office, and in-house experience. And I hope you learned a lot from all of us. Thank you.
Thank you.
Thank you.